Fascinating topic, and it is fascinating, of ethical considerations in mixed mode dispute resolution processes. And it really goes to two of the fundamental goals underlying ADR. The first goal of ADR is to use various tools at our disposal: settlement, mediation, arbitration, whether sequentially or together, to achieve a process that is fast and effective and cost efficient, and that is tailored to the parties and the disputes at hand. The second goal is to make sure that the process has integrity, that it's fair to all of the parties, and last but not least, that it withstands any subsequent challenge, judicial or otherwise. So the question is, how do we ensure that these goals align and don't come into conflict? And to help us navigate these issues, we have a fantastic panel who come at this from three critically important perspectives. We have a senior in-house counsel to give us the client perspective. We have a distinguished neutral, and we have an ethics expert. And let me briefly introduce them. They probably don't need an introduction, but let me do it quickly. To my far left, and I should say we have two Steves, Steve A and Steve B, which has caused some confusion, but
here's the way to tell. One has a little bit of hair, one has no hair.
So Steve Antunes is Senior Litigation Counsel at Aegis Insurance Services. He is responsible for the management and resolution of environmental claims and disputes. He has been involved in many of the largest and I would say most important environmental matters in the country. And he currently serves as co-chair of the CPR Council. Next to him is Stephen Bierman, who's an independent arbitrator, mediator, and dispute resolution advisor. He's the founder of Bierman ADR LLC. He serves on multiple private and court ADR rosters. As I was going through his CV, I had to shorten this because it would go on forever. But among other things, he is a fellow of the Chartered Institute of Arbitrators. He is the chair of the ABA's Advanced Mediation and Advocacy Institute. He is a co-chair of CPR's Mediation Council and a member of the CPR Council. And prior to all that, he was a litigation partner at Sidley and Austin. He headed the New York litigation group for 25 years and was co-leader of the global disputes and litigation practice. Then we have Ellen Waldman, who is the Vice President of Advocacy and Educational Outreach at CPR. She is responsible for continuing to grow CPR's relationship with academic institutions, as well as working on diversity and dispute resolution. Before CPR, Ellen was professor and director of the Mediation Clinic at the Thomas Jefferson Law School in San Diego. She is the author of Mediation Cases and Commentaries, which is the first full-length treatment on the subject. So we have really a panel of true experts to help us navigate through these issues. So, let's see. There we go. Over the next 45 minutes or so, we're going to provide an overview of various mixed-mode dispute resolution processes, of key ethical rules at issue, and of the tension, or at least the potential tension, between party expectations and party desires on the one hand, and ethical rules on the other. Here's the roadmap, but let's get right into it and start with why can't the arbitrator do it all? Let's assume that there's no specified arb-mead or arb-mead-arb or similar process. The arbitrator has been handling the case. She knows the facts. She knows the issues. Ellen, why can't the arbitrator encourage the parties to consider settlement negotiation or mediation? Why can't she go a step further and try to mediate a case that she's presiding over? Wouldn't that be much more efficient and effective? Can she do it? What are the rules?
So thank you for that multi-compound question. And
Objection.
let me see if I can unpack that a little bit. So first, can the arbitrator encourage settlement? And the answer is yes. There's no ethical bar, and in fact, I think it's a fairly common practice in certain subject matter areas, certain regions. There continues to be some discussion and writing around the issue, suggesting that the arbitrator needs to take care not to tip his or her hand in encouraging the parties to talk to one another and see if they can reach a consensual settlement. But there's no ethical bar. You've also mentioned, can the arbitrator, mention to the parties the possibility of mediation? And that is also ethically permissible. But then you went a step further and said, can the arbitrator say to the parties, this seems like a case that is ripe for mediation, and I'm pretty much the guy or the gal who can help move you through this. And that is problematic on a number of different levels. So we're going to take a moment and take a look at the ABA AAA code governing an arbitrator's conduct, and you'll see this is a move that should only be triggered by the party's request, and really only after an in-depth discussion of the risks and pitfalls that such a shift from the arbitral role to a mediative role entails. So just some table setting. Where do we find the ethical rules for arbitrators and, for that matter, mediators? I probably don't need to talk about this in this room, but there are several sources. The most generally accepted codification drafted by the ABA, AAA, but we can find other sources, other ADR providers. For example, CPR has a wealth of guidance and rules that are very thoughtful and deliberate. ADR neutral associations, various states, court annex programs, these all are sources of ethical guidance. And some of them adopt the ABA, AAA rules wholesale, others deviate slightly, so it's important to take a look at those rules. Next slide. So, back a slide. Thanks. So the ethical rules guiding arbitrator conduct are really designed to ensure the fairness and integrity of the arbitration process, right? So the arbitrator's job is to listen in an objective and unbiased fashion to the parties' arguments and proof, and come to a fair and diligently considered decision according to the law of the contract or the relevant statute or treaty. As part of this imperative, arbitrators are required to avoid impropriety in communicating with the parties, which usually means no ex parte communications with either side, and to safeguard the relationship of trust that exists between arbitrator and party by maintaining certain boundaries of formality and distance. Ideally, the party's confidence in the process is assured by the fact that all information communicated to the arbitrator is subject to review, cross-examination, and the opportunity for rebuttal by the opposing party. Of course, in mediation, the assumptions regarding communications with the neutral are entirely different, driven by the different goals and imperatives of that process. Okay, now next slide. So it's important to note here, first, implicit in the willingness to assume a different role is the ethical mandate that the neutral be competent to do so. So when a neutral says, I can switch roles here, what she's really saying is, I have the knowledge, skills, and experience to capably carry out this new role, which is a role separate and apart from the one I was originally hired to perform. And pertinently, for the question of whether an arbitrator can move into a mediative role, the ethics rules are clear that arbitrators should not be involved in settlement discussions. They shouldn't serve as a mediator unless the parties ask them. And as we're going to discuss further, it would be really wise for the arbitrator to memorialize that request in writing. As Steve B. is going to discuss further, the ethical problem with ArbMed, assuming the arbitrator has the competence to actually function effectively as a mediator, does not really arise if the mediation is successful and the arbitrator turned mediator is actually able to help the parties reach a consensual settlement, which can then be incorporated into a consent award. The real problem arises if the mediation fails, and the expectation is that that same arbitrator who has functioned as a mediator is going to revert back to the arbitral role and issue a binding ruling in this same dispute.
Okay, so that's interesting. Steve B. And one of the pleasures of being the moderator is I get to ask compound questions, unlike in a deposition. Ellen just told us that under Canon 4F, an arbitrator can participate in settlement discussions, can act as a mediator if the parties ask him to, if there is party consent. So given that the ethical rules that Ellen just cited seem to allow it, why doesn't it happen more often? I mean, wouldn't that be a good way to resolve cases quickly and efficiently and cost effectively?
Why, yes, Alex. It would be a way to resolve cases efficiently and cost effectively. And everyone is here at this program because they believe in finding ways to have efficient and cost-effective resolution of matters. And that's what ADR neutrals want to provide to the parties as well. So it does seem that having an arbitrator switch hats to being a mediator in a matter, that would seem to check the box, right? And in fact, in some parts of the world, it does. There are different experiences around the world. It's worth taking a moment to just take a snapshot. In some countries, it's very common for a neutral to switch roles. Germany, for example, where judges have a tradition of being involved in settlement discussions with the parties. That has carried over to the ADR practice in that country. Likewise, Switzerland, Japan, China, Israel, a blurring of lines. Let me see, is Raphael still here? Raphael, if he were here, would tell you, no. In Brazil, we don't do that, and it's not part of the legal culture there. In the United States, it's kind of a mixed bag. There's been long historical skepticism or hesitation about neutrals switching roles. And there are some reasons I'm going to mention in a moment why that may be the case. It's an evolving situation, and I think the attitude is becoming generally more permissive as time goes by. I think that's been evolving for a couple of reasons. For one, in the last 10, 15 years in particular, there's been much more recognition of the idea that in using the tools in the toolbox, it maybe makes sense to pair up appropriately arbitration and mediation, or mediation and arbitration. And more parties and more neutrals are getting experience with doing that and learning how to navigate it. So that's one reason. Another is there's been very robust legal scholarship over the last 10, 15 years in particular about these questions. And we've included in the CLE materials in the bundle that you all have electronically a couple of just seminal articles by Tom Stepanowicz, whom many of you will remember was formerly of CPR. But these are recent articles, 2020, 2021. And a collection of articles that describes the work of a landmark kind of project, the IMI, Pepperdine, CCA, International Mixed Mode Task Force, which looks at a number of issues surrounding mixed mode mixing and matching. And there's a collection of articles there too. So it's been liberalizing, but there remain some important reasons why you don't see it more often still in the United States. The future lies before us, of course. One of the reasons is, as Ellen mentioned, there are some provider organizations or rules promulgators that may be applicable, whose rules may be applicable to a particular matter that say you can't do it. And if you're under that regime, you can't do it. Another reason may be that you have to check, you always have to check. If Helena were here, she would remind me to say you always have to check state law, local law, because maybe there's some case law that's a gloss on these issues. But apart from those kind of threshold concerns, arbitration and mediation are obviously distinct processes, very different goals, very different methods, and very different skills that are required to do each. And whether it's because of the ethical considerations that we're unpacking here, or whether it's just personal practice inclination, there are a lot of neutrals in the US who stay in one lane or another. They are principally arbitrators or principally mediators. They maybe don't have training in the other one. As Ellen mentioned, it's important that you don't just say, I could do that, but rather you really have to be competent to do that. So for those reasons, you don't see it more often than you do. And from the parties' perspectives, and Steve A. is going to comment on this in just a little bit, it may be that ethics aside, all these other considerations aside, the parties just would like to have someone separate to handle the facilitated negotiation of mediation rather than the arbitrator. There could be all kinds of reasons. Running throughout all of these practical kind of factors are the ethical guidelines that Ellen started to unfold, and she'll do a little bit more when we flip the question around to why can't the mediator do it all. And all of these ethical considerations raise questions not only of the competence of the arbitrator to switch to being the mediator, but the arbitrator's impartiality, the effect on the fairness of the process and the perception of the fairness of the process, and treatment of confidential information. Having said that, and with all of these qualifications, where requested by all parties, as opposed to coming from the arbitrator's mouth, but where requested by all parties, it's a party-driven idea, where the provider rules and applicable law don't prevent it, and where the arbitrator is competent to sit as a mediator, an arbitrator may well be able to switch to acting as the mediator. In other words, arb-med, as the saying goes. And in a perfect world, the perfect world where it's springtime always, and butterflies are flitting about, and my hair has regrown.
It never rains
And
at
it's not
lunch.
cold.
And it's not cold in the room. In that perfect world, of course, it ends there. The arbitrator will now switch to being a mediator, and as a mediator will help the parties resolve the case, and everyone should be happy. But in the actual real world, we know it frequently does not end there. We know that mediation, even in the window that was mentioned, the window within arbitration, mediation may not be successful, and then it's back to arbitration. And so accordingly, the neutral counsel and the parties must assume it will not end at arb-med. So if the mediation fails and the neutral is expected to resume as arbitrator, in other words, arb-med-arb, there are serious issues that may be anticipated regarding that return trip. And it's chiefly because of what typically happens in a mediation, in that middle role of serving as a mediator, arb-med-arb. In particular, the concern stems from the prevalent use in mediation, at least in the United States, of caucuses, and associated with caucusing, ex parte provision of information, confidential information to the mediator. So arbitrators contemplating moving into a mediation role worry about whether the intimacy of the caucus, of caucus communications, where parties may reveal vulnerabilities and share confidential information, and mediators may provide candid assessments of various aspects of the case. That's potentially problematic for then switching the hat again and going back to being the arm's length arbitrator. And so if there is any contemplation of asking an arbitrator to switch roles later and act as mediator, it's not enough just to think about, is it okay to switch to being a mediator? it's really prudent to think about from the outset of that discussion and that consideration, what happens if there is to be that return trip to resumption of arbitration and resumption of the role as an arbitrator. There's a way to do it, takes some work and commitment, but let's leave how to do it till the next segment, okay?
Thank you, Steve. You know, Steve B. mentioned the German tradition. I just want to read German Arbitration Institute Article 26, quote, "Unless any party objects, the arbitral tribunal shall, at every stage of the arbitration, seek to encourage an amicable settlement of the dispute or of individual disputed issues."
And it is no mediation. A German arbitrator would never caucus with one party if the other party is not in the room. So it is a misunderstanding that it would be a mediation.
Yeah, but even,
How if they want to settle, but if all parties are in the room at the same time, never caucusing.
that's a great point.
Well-
And
And it's a great observation, and it actually previews something we're going to talk about in just a bit. One of the ways to deal with the dilemmas that caucusing in mediation creates is not to have caucuses and to do the entire mediation in joint session. We'll talk a little bit more about that.
yeah, but Steve A., before we do, tell us about the client's perspective. I mean, why wouldn't the client want the arbitrator to jump in the mix, especially when she already knows the law and the facts? I mean, wouldn't that be a more cost-effective, efficient way of dealing things? What about, you know, the German approach of at least encouraging settlement, if not jumping into the fray as mediators?
Thank you, Alex. And I just want to point out it's an honor to participate in this type of esteemed panel. You know, it's also nice to be able to get together again, so thank you all for being here. And, you know, especially it's good to be the last panel right after a break at the end of the day to discuss ethics. So that's always a good thing.
For them or for us?
Well, for them.
All right.
You know, the most valuable contribution I can give to this particular session is listen to these three people, because these three esteemed professionals know this area. These folks have lived it. These guys have done it. So that's who I would listen to. I can only come to you with my own personal in-house experience. I'm not saying it's the right way, and to parrot what somebody said earlier today, these are just my views, not the company's, nobody else's. And again, it's only my experience. And hopefully, as we continue with this panel, it's nowhere near as frightening as yesterday's cyber panel. That one scared me. So thank you all for laying all that out yesterday. You know, we've heard it time and time again in the last couple days, and earlier today and just now. The primary ADR objective for in-house counsel and your client, you know, is reaching a fair, reasonable resolution in the most cost-effective manner possible. You know, and I just want to throw out, you know, if I'm going to be completely honest, because clearly that's what you're all waiting for. If I were to be completely honest, I'm not 100% sure the ethics of the mediator or arbitrator is anything that enters my consciousness in the beginning of the process. And you know, the company that employs me presumes that in the capacity of my position, I understand the ethics involved for both parties and the mediator and or arbitrator. As in-house counsel, I presume, upon retention of outside counsel, that they do the same. I mean, maybe we're asking a lot, but I think that's just predicated. Everything moving forward is predicated on folks acting ethically and responsibly. Does the client want the arbitrator to assist in resolving the case? I think that the client, my client, welcomes any legitimate assistance in reaching the desired resolution. That being said, and to answer your question directly, Alex, no, I have never asked an arbitrator to step in as a mediator, and for a valid reason. You know, Steve mentioned context, and one of the things, again, from my own perspective, each and every one of our agreements has a built-in three-step ADR process. And here's a CPR pitch coming. We adhere to CPR rules, and it's specifically stated in the contract. And it's something that you've all heard of. You know, it's your good faith negotiation, followed by the mediation, followed by the arbitration. You know, the arbitration is conducted, you know, in front of a tribunal, you know, consisting of two-party appointees and a mutually agreed upon neutral. And as you all be able to relate, you know, that's always a joy to come up with that third-party neutral, because if you recommend them, obviously I don't like them, and vice versa, and then, you know, the whole trust thing goes out the window, and then who cares who the mediator or arbitrator are? You never get there. Clearly, this has a direct effect on the topic at hand, right? My point being that by the time, in my circumstances, we get to an arbitrator, we reach the arbitrator, costs, again, a concern for all, costs have already been incurred. We've already paid a mediator. The mediator has already gone through the process. If we're going to the arbitrator, obviously we were unsuccessful. Is somebody willing to pay somebody else? Is somebody willing to say, well, these people already know? Again, and we'll talk about it more when we flip it. But my point is the order of the process is important. And it plays a significant role as to how you're going to move forward. You know, and perhaps, you know, we can discuss the possibility of a mediator being an arbitrator in a case, and whether that poses a different set of problems.
Okay. Thank you. I mean, that's a very, very interesting perspective, and Steve A., having you on this panel really has helped us understand this from the client perspective. And so let's move to the next topic, which in some part arises out of what Steve just told us. Why can't the mediator do it all? I mean, if we have a sequential process where there are settlement discussions and then a mediation, why don't we just ask the mediator, who, again, knows the facts and the issues and the parties, to step in the role of the arbitrator? Ellen, what are the ethical rules about that?
Next slide, thank you. So as Steve B. mentioned earlier, the processes are really distinct, right? Mediation, arbitration, they have different goals, they have different methods, and they have different moralities, right? So the morality of mediation is grounded in optimum settlement, in the neutrals helping the parties uncover the ideal set of trades and accommodations that will best meet their joint interests, right? The morality of arbitration lies in a decision according to the law of the contract. So given these different goals, it's not surprising that a key aspect of mediation involves a candid, intimate exchange. And Steve used the term intimate also, and I think that's the right word to use when you talk about the communications between a mediator and a party. These are the sorts of communications that are sort of declared, you know, per se verboten, per se inappropriate for arbitration. So again, the problems arise, as Steve B. mentioned, when we're considering a mediation where there's been this exchange, this intimate reveal of vulnerabilities. The parties have sort of said, yeah, maybe we contributed to the dispute in this particular fashion, and here are our weaknesses. And the mediator has said, yeah, I really don't think it's a seven-figure case, right? Think about how that's going to work when the neutral is now moving into an arbitral role. And Steve, sorry, I'm stealing your thunder there. Okay, so let's take a look at the ethics rules for mediators. If the primary thrust of the ethics codes for arbitrators is to ensure due process, procedural integrity, create optimal conditions whereby a third party can consider party evidence and argument and apply relevant norms to reach a fair decision. The ethics rules for mediators focus on the party's right to self-determination, their right to have the dispute facilitated by an impartial neutral with no stake in the outcome, who's going to help the parties determine for themselves what sort of outcome best meets their mutual interests, right? So one sees in the ABA, AAA standards, the model standards of conduct for mediators, which are, pick whatever holy book you ascribe to. It's our Bible, it's our Quran, it's our guiding light, our North Star. If you look at that text, right, you'll see Standard 5A acknowledges the role of a mediator differs substantially from other professional roles, and mixing the role of a mediator and the role of another profession is problematic. I think that's maybe our next slide. Thanks. So the drafters of these standards were super careful to emphasize that it's entirely inappropriate for a mediator to move into a different role without obtaining the informed consent of the parties. So the mediator has to take the time to explain the implication of such a shift, what it means for the dispute resolution process, and the risks and the benefits involved in such a shift. The rules also clarify that a mediator who moves into an arbitral role now becomes subject to the ethics rules that apply to arbitrators, including the obligation to be competent, of course, to preside over this very different process, as well as preserving party trust and managing confidential communications in a responsible fashion, which raises the question that we've been circling around of being able to issue a truly impartial and fair award after having been privy to some of the parties' unburdening of themselves in a private caucus, right? Mediators are obligated to maintain the confidentiality of the information they receive in trust during a private caucus, and this means not using it consciously or unconsciously as a basis of an award. So a mediator who moves into the arbitral role is still subject to the mediator's duty to preserve the confidentiality of information communicated in confidence while the mediator was still in that facilitative role. But how does one do that? How does one keep a secret from oneself? Ethically, this role shifting requires considerable gymnastics to be able to simultaneously conform to the rules that guide the conduct of mediators and arbitrators.
So Alan has articulated some really challenging issues and questions, and as moderator, I get to put them to Steve B. Steve B., you've acted as counsel, as arbitrator, as moderator. What is the practical... did I not say mediator? Oh, did I say moderator? Yeah. That too.
I've also acted as moderator.
And given all of those roles, what is the practical interplay between shifting roles given the ethical rules? And have you ever gone back and forth have you ever changed hats in that fashion?
The interplay between the ethical concerns and kind of practical issues is that the ethical concerns drive the practical issues. They're not unrelated to each other. And I have been asked to switch hats. In the particular circumstances that I have in mind, it wasn't appropriate because of the time when the parties raised it with me, and that's going to come into the issue we're going to talk about in a moment, about the importance of planning from the outset. If you wait until you're in the middle of the mediation, when you've been doing the caucusing, with the consequences that we've been gradually unpacking here, and then they say, well, if this doesn't work out, maybe you can be the arbitrator after this. it's kind of too late to unring the bell. So in the particular circumstances that I've been involved in, no, I've declined to switch hats, but it is doable. And I can envision a situation and circumstances in which it is doable. And there are a number of people in the room here who have done it. So it certainly is doable. You know, interesting that you mentioned the different hats that I might have worn, just not at the same time, not switching them, but at different times. Because everyone in the process has a stake in these issues. You know, the arbitrator or the mediator has an obvious obligation to adhere to these ethical requirements. They're not aspirational. They're not, unless the parties really mind, you have to do it. The neutrals are obligated to act ethically. And beyond that, though, counsel may say, well, that's interesting, good luck, what's it got to do with me? But the truth of the matter is that everyone has this stake in it. Counsel, whether they're in-house or outside counsel, are bound themselves in the United States by the model rules of professional conduct. And there's a competence requirement there as well. And that competence requirement, I would suggest, includes being sufficiently educated about these issues so that when it comes up, or when it might come up, or when you or your client may want to raise it, you're in a position to deal with it in an informed, knowledgeable way. So we've a couple times now danced up to the problems and the potential constraints that arise from the way mediations are conducted. I'd like to, Alex, I think just walk ahead a little bit and let's lay out clearly what are these risks. We've been talking about caucus, we've been talking about confidential information. So I think it's fair to say that in the States, as opposed to some other jurisdictions around the world, while mediator styles may vary and party expectations or preferences may vary, the most common expectation is that the hard work in a mediation is going to get done in the caucus sessions. And that is a presumption, whether stated literally, and it should be, but even if not, that the intention is that the contents of the caucus sessions be kept confidential from the other side unless the mediator receives permission to disclose information from that private session. So when you pull back the curtain, what happens in these caucus sessions? And obviously many, many people here know exactly what happens, but let me just tick a few things off. So in caucus, a party or counsel might share confidential factual information. Don't tell the other side this. Or might express private views as to the strengths and weaknesses or valuation of the claims. I had a fellow mediator tell me not long ago, I'm looking forward to the day when counsel or their client actually expresses to me weaknesses in the caucus session. But in any event, a person's reach should exceed their grasp, and you know what the rest of that is. In any event, there may be these intimate, as we've referred to a couple times, discussions about the case in private caucus. It may be that the parties or counsel ask the mediator to give an assessment, whether it's called formally an evaluation or it's just in the interplay of conversation. What's your take on some of these issues? Now, once confidential information is shared, once with the mediator, once vulnerabilities are discussed, or once the mediator expresses his or her views to some extent, how do you then go back to serving as the neutral, where you're in an adjudicative role as an arbitrator? And for that matter, even if a mediator is not being evaluative and not being asked literally for an evaluation and not giving such, and the mediator instead is more facilitative. As we all know, one of the major techniques that mediators use in caucus is reality testing, kicking the tires, playing devil's advocate. The way the mediator even frames those questions with all the qualifications about, I'm not taking the other side's view, this is not what I really think, but have you considered fill in the blank? it kind of reveals what the mediator's thought process is. And is that going to get scrubbed out of the mediator's brain? And maybe more importantly, is it going to get scrubbed out of the listener's memory when you go back to being adjudicative? What about claim valuation? What if the parties or the mediator are talking about what the claim's range is really worth? Well, when you go back to being the arbitrator, if that's, or go to being the arbitrator, if it's meet-arb, as opposed to arb-meet-arb, is there an expectation of the parties that the now adjudicator is going to have that valuation or a range of valuation in mind for any award? And of course, the hallmark of caucus sessions is to talk about potential settlement and settlement strategy and offers and the like. That's going to stick in the mediator's brain. And if you reach a point of impasse and parties decide that it's a good thing to do a bracketed negotiation, is that bracket going to carry over in anyone's mind to the adjudication phase if it comes back to that? So in essence, can any of these bells ever be unrung? And the practical question is, how does a mediator in these circumstances transition from a compromised facilitator and confidant, in a way, to a fair, impartial, arm's-length arbitrator? And that's whether it's arb, then meet, and arb, or whether it's starting with meet and going to arb. So the answer, and there is an answer, the answer lies in taking the issue head-on, and taking it head-on from as early in the process as is possible. In fact, a best practice might be that before the individual, the potential neutral, even takes on the initial role, if there's any possibility of being asked to take on another role, it's important that the neutral and counsel and the parties have a frank discussion about these issues, and that they consider any or all of several possible procedural guardrails that might address this litany of problems that I've laid out here. I was chatting with Homer LaRue earlier, and he said something that I thought just crystallized this so well. When I'm serving as a neutral and there's potential of switching hats, I want to achieve clarity. It is so important to get to clarity, because you don't want later on that people didn't quite hear it, people didn't quite understand it, something was implied. One side of the V was more attuned to these issues, the other was just bumping along and not really clued into it. So clarity is so important. So what are some of these procedural guardrails that might get us to a better place? As we mentioned before when talking about the German experience, one way to do it is to agree up front that any mediation will be conducted entirely in joint session. Now, in this country, in quite a number of geographic areas around the U.S. and a number of subject areas and industries, the joint session has kind of atrophied, and much more is put into caucus. You so often have counsel saying, we're not going to get a lot out of poking each other in the eye in a joint session, to which my response always is, here's an idea. Don't poke them in the eye. You know? It
Brilliant.
doesn't seem to change anyone's mind, but I do say it. In any event, back in the day, mediations were conducted primarily in joint session. There's no reason why they can't be. And there are neutrals in this room and neutrals not in this room who, when they're asked to switch hats, will insist on the mediation being conducted in joint session. Alternatively, allow caucuses to go forward. Allow confidential information to be disclosed to the mediator, and then take one of two potential paths. Either have the agreement up front that if that happens, any confidential information disclosed, if the mediator is then to sit as the arbitrator, that all confidential information will be shared with the other side. So be careful what you disclose, because it would be shared with the other side. The other fork of that road is to just say that the mediator, when sitting next as an arbitrator, will not rely on any of that confidential information in thinking about and framing an award. That one has always struck me as a little easier said than done. Another option, kind of at the end of it, is as a safety valve, agree up front that if at the end of the mediation, and there's a prospect of either an arbitration or in the ARB-meet-ARB context, a continued arbitration, a resumed arbitration, allow any party or the neutral to opt out if there's any discomfort. So the ABA model standards for mediators prescribe, as Ellen pointed out so well, that it's critical to fully inform the parties of the implications of switching roles and the impact on process. And the mediator should obtain the parties' informed consent to the change in roles and the change in process. In fact, a best practice, and it's more than a best practice, I think neutrals would agree with me, it's an essential practice, that after having a full and frank discussion with counsel and parties about these risks, about the implications, about ways to navigate around them, and reaching an agreement as to which of those ways might be adopted for the particular matter, get the parties and the neutral for that matter to put it all in writing. And indeed, many neutrals, I do, others in the room, I see Homer nodding, have a form or a form of agreement that can be tailored should the situation arise. And that writing should include that it's the parties that requested this, that the parties jointly and unanimously requested it. Can't be one party requests it and not the other. That they understand the issues and they consent to the implications of the issues, and you go from there. This requires real engagement, of course, but the bottom line is if parties really want the mediator to serve as the arbitrator in either of the scenarios, ARB-meet-ARB or meet-ARB, and they say, yeah, we get all that, but we really want you to do it for all kinds of reasons. It's doable. It just takes real engagement and it takes work and care.
Steve A., that sounds really, really hard. It's challenging. Ethical guardrails have to be put in place. From the client's perspective, can you envision any circumstances where it would be worth it, where it would be a good idea for the mediators to switch roles and act as the arbitrator?
Well, I'm a big believer in pro and con lists. So, on its face, it would clearly appear to fulfill one of the charges to keep for in-house counsel, right? And that is cost containment. You don't have to pay someone else. You don't have to re-educate someone else regarding the facts and circumstances of the case. We could probably place that in the pro column. That, okay, well, I have no objection to that. But when you're in-house and you're dealing with the business folks, sometimes, despite you're in collaboration with outside counsel, and, this is a deviation from the norm. It's something that, they may not have come across yet. And, you have to sell it to the business decision makers, despite the fact it's a legal issue. And some of you may have encountered, that sometimes it's much harder to convince the folks within your organization than it is the other side to get something done and to reach a common goal. So I guess that one is a toss-up. You can put it in whichever column you prefer. Clearly every aspect of what Ellen and Steve discussed, need to be taken into account. Of particular interest to me is exactly what Steve just discussed regarding the information, and Ellen discussed how do you unhear what you've heard. You can't ask somebody to. This information has already been received and processed in a, 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 getting Is it possible to categorize this as a push in a pro-con? Maybe. Maybe. Again, we leave that up to you. It's how you're going to determine things. But again, cost containment, the aspect of ADR is always looming in the background. I'd like to point out the possibility of a mediator assuming the role of arbiter would not be as viable if you're moving up to a tribunal in the arbitration, because that just makes things even more difficult. Because as I previously indicated, our contracts are very clear. It's a tribunal, party appointed, and then the two-party appointed somehow miraculously maybe reach an agreement on who the third-party neutral would be. Well, again, going back to how that information was received and processed, you can't determine how that individual, how is that going to play with two people who, let's face it, they're appointed by their party to have their own position, right? And the point of the neutral is to be that deciding vote, for lack of a better term, So, these things need to, it has to play out. And this knowledge, you don't know how it's going to play out. Is that appropriate for the arbitration? Again, you put it in whichever column you prefer. I lean towards that being a con. John?
I've got a comment and a question. I'm not so quite equivocal. I won't do it, okay? Haven't done it. I don't think a mediator in becoming an arbitrator works, even in joint session. You're not going to just be the proverbial potted plant, and you're going to ask questions. You're going to perhaps give a wrong impression. What I do is I'll arbitrate and then mediate. And I've done that successfully. And one ER won't do it, but if you come to me, and it won't work for all cases, I will hear you, maybe in a truncated process, make a decision, seal my decision, now let's go mediate. You settle, great, you never find out my decision. You don't settle, you tell me, I open up the envelope. I got a great story, but I'm not going to tell it now. How I got overturned by the Supreme Court, but that's for another one. You give the case. I can.
But that sounds like a good story.
Cougar down, okay? But that's a longer story and not time right now. A friend of mine who does divorce mediation, he does something very clever. I wouldn't do it, but it works for him. And divorce is, of course, one of the most emotional topics to do. And he will sit in his mediation and he'll type on a computer everything that's going on in caucus so the other side sees it. And so then they all have, in theory, the same information. Now, he won't arbitrate, but it's an interesting concept to perhaps apply. Don't know. The question I have, which does come up from time to time, is after you successfully do a mediation, the parties say, gosh, we really like you. We're going to put you in our settlement agreement to arbitrate any disputes we have going forward. And that's happened to me sometimes without my knowledge. What do you think of that?
What do you think of that?
Well, interesting.
It's a different dispute, John. So, different considerations. Like, I'm good with that.
And really what you're demonstrating is that one size does not fit all. There are different permutations in this. And it also demonstrates that the trip is easier from arbitrator to mediator than it is from mediator to arbitrator.
Yeah. Let me suggest this. There are lots of questions. Why don't we open the floor to questions? If anyone has questions about relationship facilitators, processes, designers,
Well,
we're happy to take those.
let's just do one. You're on for 1 minute.
Oh, no.
It'll be a Steve B minute, though, so
I was
you have your own
trying-
time.
I was trying a case one time. This is not counted, right? I was trying a case one time, and I had just a couple of minutes left from what the judge had allocated me. And all of a sudden, the opposing counsel starts making an objection. I interjected and said, "Is this counting against my time?" So in any event, let me be really quick. We wanted to mention just briefly a couple of very innovative tools that CPR has developed that are additional hybrid mixed mode kinds of approaches to problem solving. You heard about one in preview this morning, and that was the CPR therapist. What that actually is called by CPR is a relationship facilitator. And there's a protocol to it, but the basic idea is that the parties agree that they want to collaborate. In a long-term supply contract or a long-term commercial arrangement, they agree that they want to collaborate and cooperate to avoid disputes. They appoint someone from each company to meet regularly. They appoint a neutral called, in this parlance, a relationship facilitator, who either could be a standing neutral, be involved from the outset and be with them every step of the way, or a standby neutral in case a dispute arises. And if despite this kumbaya context, if a dispute does arise, it gets escalated progressively within each company, the mediator, the relationship facilitator can be asked to serve as mediator, and the parties can ask the then mediator to issue a report with a proposed settlement, and they can accept it or not accept it, and go from there. So anyway, it's kind of a more evolved cousin of a dispute resolution board in a way, but it's an exciting idea, and it's in progress. Joan is nodding her head up and down because she developed the training for relationship facilitators. It's been beta tested by CPR. It's an exciting potential additional tool in the toolbox. And the other one, very quickly, is what CPR is calling a B2B dispute process design tool. And that's based on the premise that parties, when a dispute arises, often haven't really thought through what the best protocol is for addressing a dispute, or they're relying on a dispute resolution clause that was drafted many years before, if it was drafted at all, as opposed to being lifted from another agreement. And this is a chance to develop a bespoke process by using what CPR is referring to as a process design facilitator. The basic idea, in a nutshell, is the parties who are interested in this sign up for up to four free, did I mention free, hours in a pilot program that CPR has. They would meet with a neutral who is experienced in many modes of dispute resolution. The neutral would meet with them separately to kind of suss out what are their drivers, cost, timing, the relationship, then get them together with the neutral to talk about optionality for designing a really bespoke process. It's a pilot program, as I said. I had the really good fortune to be not just involved with CPR in helping to develop this, but I was the pilot neutral, the pilot process design facilitator in the pilot matter in the pilot program. And it was a great experience. You know, you'll be hearing more about it, I'm sure, from CPR. It has a lot of potential as a way to just step back and find a better way to solve the problem.
Okay, so Steve B is very excited about that. I'm very excited about getting some questions from the audience. We only have a little bit of time, so please keep the questions short.
Yeah, very quickly, one thing you were talking about, the differences between mediation and arbitration, moving back and forth. I think one, and maybe I didn't hear it, but I think
I can't hear you.
One important distinction is in a mediation, you can always walk away. And in arbitration, when you're in, you're in. You have to go to completion. I think that was sort of, you merged that concept a little bit, I think, but I'm not, I thought I wanted to clarify that. The second thing, which when you talk about moving from mediation to arbitration, and maybe this only works in the insurance context because of the different floating issues and also a case within a case, that we have started with an arbitration, mediated. Within the mediation, we resolved it, but created a new arbitration because there was a new issue that we figured out was what stood between the parties in the ultimate resolution. So we carved out one last issue to arbitrate, and then once we were done, it was over.
And who did you have then do the arbitration?
John Bickerman.
All right.
We're pretty much out of time, but I do want to we've been the College of Commercial Arbitrators. You've heard Tom Sabanovich and Edna Sussman, about 15 others of us have been working over the last 10, 15 years to perfect these mixed modal processes. Really, I wish we had more time to explore this because it's about giving parties the processes that they want that achieve all of these efficiencies that CPR is all about. You can do this. There's a way to do it. Jerry Phillips, God rest his soul, when he came to us about 20 years ago, to a person, every one of us, including me, said, no, ethically you can't do it. 20 years later, you can do it. There's a way to do it. Please read those CCA guidelines because this is a game changer. Thank you very much.